Assalamualaikum warahmatullahi wabarakatuh. Today I will explain about English in law. Today I am at Taiwan. The weather is very cool, so that's why I am using the scarf. Okay, I will explain about law. Law is a system of rules of society sets to maintain order and protect harm to persons and property. Such systems are ancient, dating back at least to the Code of Hammurabi, written by an ancient Babylonian king around 1760 before Christ. Most countries have tens or hundreds of thousands of pages of laws. They are enforced by the police, supported by the court and prison systems. Laws are written by legislators such as senators or congressmen. In America and many other countries, those rules must uphold and not contradict the Constitution, a document outlining the most basic rules of the country. Aside from law being a set of rules, the word also refers to the profession practiced by lawyers who either prosecute or defend a client from an accusation of violating the law. Becoming a lawyer requires attending law school and passing a bar exam. This entitles the lawyer to a license. Only lawyers with a license are allowed to practice. There are many categories of law. These include contract, property, trust, tort, criminal, constitutional, administrative, and international. Each of these sets the rules for a distinct area of human activity. Without laws, there is a lawlessness, which historically has led to a general breakdown in society, sometimes to the point near stands still in the economy. Those that advocate the abolition of laws are called anarchists. Depending on one's political orientation, they will generally favor more or less law. At one end of the spectrum are libertarians who advocate minimal rules or government intervention into the affairs of the public. At the other end are fascists who seek to create laws regulating practically everything, generally under the assumption that a disciplined nation will be a powerful nation. Historically, most fascist governments have collapsed. Okay, so and then I will explain about legal history. Legal history, or the history of law, is the study of how a law has evolved and why it changed. Legal history is closely connected to the development of civilization and is set in the wider context of social history. Among certain jurists and historians of legal process, it has been seen as the recording of the evolution of laws and the technical explanation of how these laws have evolved with a view of better understanding the origins of various legal concepts. Some consider it a branch of intellectual history. 20th century historians have viewed legal history in a more contextualist manner, more in line with the thinking of social historians. They have looked at legal institution as complex system of rules, players, and symbols, and have seen these elements interact with society to change, adapt, or resist, or promote certain aspects of civil society. Such legal historians have tended to analyze case histories from the parameter of social science inquiry using using statistical methods, analyzing class distinction among litigation, petitioner, and other players in various legal processes. By analyzing case outcome, transaction costs, number of settled cases, they have begun an analysis of legal institutions, practices, procedures, and brief that give us a more complex picture of law and society than the study of jurisprudence, case law, and civil courts can achieve. Uh, Ancient Egyptian law, dating as far back as 3000 before Christ, had a civil code that was probably broken into 12 books. It was based on the concept of ma'at, but characterized by tradition, rhetorical speech, social equality, and impartiality. By the 22nd century before Christ, Namu, an ancient Sumerian rule, formulated the first law code consisting of casuistic statements. Ifde. Around 7060 before Christ, King Hammurabi further developed Babylonian law by codifying and inscribing it in stone. Hammurabi placed several copies of his law code throughout the kingdom of Babylon as stele for the entire public to see. This became known as the Codex Hammurabi. The most intact copy of this stele was discovered in the 19th century by British Assyriologists and has since been fully translated and translated into various languages, including English, German, and French. Ancient Athens, the small Greek city-state, was the first society based on broad inclusion of the citizenry, excluding women and the slave class. Athens had no legal science, and ancient Greek has no word for law as an abstract concept, retaining instead the distinction between divine law or themis, human decree or nomos, and custom or type. Yet, ancient Greek law contained major constitutional innovation in the development of democracy. The next about Southern Asia. Ancient India and China represent distinct tradition of law and had historically independent school of legal theory and practice. The Arthashastra, dating from the 400 before Christ, and the Manusmriti from 100 were influential treatises in India, texts that were considered authoritative legal guidance. Manu central philosophy was tolerance and pluralism and was cited across Southeast Asia. But this Hindu tradition, along with Islamic law, was supplanted by the common law when India became part of the British Empire. Malaysia, Brunei, Singapore, and Hong Kong also adopted the common law. So, how about Eastern Asia? The Eastern Asia legal tradition reflects a unique blend of secular and religious influence. Japan was the first country to begin modernizing its legal system along Western lines by importing bits of the French, but mostly the German civil code. This partly reflected Germany's status as a rising power in the late 19th century. Similarly, traditional Chinese law gave way to westernization towards the final years of the Qing dynasty in the form of six private law courts based mainly on the Japanese model of German law. Today, Taiwanese law retains the close affinity to the codification from the period because of the split between Chiang Kai-shek nationalists who fled and Mao Zedong communists who won control of the mainland in 1949. The current legal infrastructure in the People's Republic of China was heavily influenced by Soviet socialist law, which essentially inflates administrative law at the expense of private law rights. However, because of rapid industrialization, China has been reforming, at least in terms of economic, social, and political rights. New contract in 1999 represent a turn away from administrative domination. Furthermore, after negotiation lasting 15 years, in 2001, China joined the World Trade Organization. Okay, and then I will explain about Islamic law. One of the major legal systems developed during the Middle Ages was Islamic law and jurisprudence. A number of important legal institutions were developed by Islamic jurists during the classical period of Islamic law and jurisprudence. One such institution was the Hawala, an early informal value transfer system, which is mentioned in texts of Islamic jurisprudence as early as the 8th century. Hawala itself later influenced the development of the EVA in French civil law and the EVA law in Italian law. Many social changes took place under Islam between 610 and 661, including the period of Muhammad's mission and the rule of his four immediate successors who established the Rashidun Caliphate. According to William Montgomery Wade for Muhammad, religion wasn't a private and individual matter, but rather the total response of his personality to the total situation in which he found himself. He was responding not only to the religious and intellectual aspect of the situation, but also the economic, social, and political pressures to which contemporary Mecca was subject. Bernard Lewis says that there are two important political traditions in Islam. One that views Muhammad as a statement in Medina, and another that views him as a rebel in Mecca. He sees Islam itself as a type of revolution that greatly changed the societies into which the new religion was brought. Historians generally agree that change in areas such as social security, family structure, slavery, and the rights of women improved on what was present in existing Arab society. For example, according to Lewis, Islam from the first denounced aristocratic privilege, rejected hierarchy, and adopted a formula of the carry open to the talent. Okay, how about European law? How about Roman Empire? Roman law was heavily influenced by Greek teachings. It forms the bridge to the modern legal world. Over the centuries between the rise and decline of the Roman Empire, Roman law in the days of the Roman Republic and Empire was heavily procedural, and there was no professional legal class. Instead, a lay person, Iudex, was chosen to adjudicate. Precedents were not reported. So any case law that developed with discourse and almost unrecognized. Uh, each case was to be decided afresh from the laws of the states, which mirrors the theoretical unimportance of judge decision for future case in civil law systems today. During the 6th century, in the Eastern Roman Empire, the Emperor Justinian codified and consolidated the laws that had existed in Rome so that what remained was 120 and the mass of legal texts from before. This became known as the Corpus Juris Civilis. As one legal historian wrote, Justinian consciously looked back to the golden age of Roman law and aimed to restore it to the peak it had reached 3 centuries before. During the Byzantine Empire, the Justinian Code was expanded and remained in force until the empire fell. Though it was never officially introduced to the West. Instead, following the fall of the Western Empire and in former Roman countries, the ruling classes relied on the Theodosian Code to govern natives and Germanic customary law for the Germanic incomers, a system known as a Folkreich, until the two laws blended together. Since the Roman court system had broken down, legal disputes were adjudicated according to Germanic custom by assemblies of learned law speakers in legal ceremonies and in oral proceedings that rely heavily on testimony. After much of the West was consolidated under Charlie Mackay, law became centralized so as to strengthen the royal court system and consequently case law and abolish Folkreich. However, once Charlie Mackay's kingdom, the divinative law splintered, Europe became feudalistic, and law was generally not governed above the county, municipal, or lordship level, thereby creating a highly decentralized legal culture that favored the development of customary law founded on localist case law. However, in the 11th century, Crusaders, having pillaged the Byzantine Empire, returned with Byzantine legal texts, including the Justinian Code, and scholars at the University of Bologna of Balance were the first to use them to interpret their own customary laws. Medieval European legal scholars began researching the Roman law and using its concept and prepared the way for the partial resurrection of Roman law as the modern civil law in a large part of the world. There was a great deal of resistance, so did civil law referred customary law for much of the later medieval period. After the Norman conquest of England, which introduced a Norman legal concept into medieval England, the English king's powerful judge developed a body of precedent that became the common law. In particular, Henry II instituted legal reforms and developed a system of royal court administered by a small number of judges who live in Westminster and travel throughout the kingdom. Henry II also instituted the assize, of Clarendon in 1166, which allowed for jury trials and reduced the number of trials by combat. Louis IX of France also undertook major legal reforms inspired by ecclesiastical court procedure, extend canon law evidence, and inquisitorial trial system to the royal courts. Also, judges no longer move on circuits, becoming fixed to their jurisdiction, and jurors were nominated by parties to the legal dispute rather than by the sheriff. In addition, by the 10th century, the law matured, first founded on Scandinavian church custom, then solidified by the Hanseatic Legion, took shape so that merchant court trade using familiar standards rather than the many splintered types of the local law. A precursor to modern commercial law, the law merchant emphasized the freedom of contract and alienability of property. And then about modern European law. The two main traditions of modern European law are the codified legal system of most of continental Europe and the English tradition based on case law. Nationalism grew in the 18th and 19th centuries. Lex Mercatoria was incorporated into countries' local law under new civil codes. Of this, the French Napoleonic Code and the German Beertorlitz Gesetzbuch became the most influential, as opposite to English common law, which consists of massive tomes of case law. Codes in small books are easy to export and for judges to apply. However, today there are signs that civil and common law are converging. European Union law is codified in treaties but develops through the precedents set down by the European Court of Justice. Okay, how about United States? The United States legal system developed primarily out of the English common law systems, with the exception of the state of Louisiana, which continued to follow the French civilian system after being admitted to statehood. Some concepts of Spanish law, such as the prior appropriation doctrine and community property, still persist in some United States, particularly those that were part of the Mexican Question in 1848. Under the doctrine of federalism, each state has its own separate court system, and the ability to legislate within areas not reserved to the federal government. Okay, like legal comes from Latin. Lex law has been defined as a system of rules, as any system of regulation to govern the conduct of the people of a community, society, or nation, as an interpretive concept to achieve justice, as an authority to mediate the people's interests, and even as the command of a sovereign picked by the threat of a sanction. Any system of regulation to govern the conduct of the people of a community, society, or nation in response to the need for regularity, consistency, and justice based upon collective human experience. Custom or conduct government governed by the votes of the local king were replaced by laws almost as soon as men learned to write. The earliest law book was written about 2100 before Christ for Ur-Nammu, king of Ur, a Middle Eastern city-state. Within 3 centuries, Hammurabi, king of Babylonia, had enumerated laws of private conduct, business, and legal precedents, of which 282 articles have survived. The term eye for an eye, or the equivalent value, is found there, as is drowning as punishment for adultery by a wife, while a husband could have slave concubines, and unequal treatment of the rich and the poor was codified here first. It took another 1,000 years before written law codes developed among the Greek city-states, particularly Athens and Israel. China developed similar rules of conduct as did Egypt. The first law system, which has a direct influence on the American legal system, was the codification of all classic law ordered by the Roman Emperor Justinian in 528 and completed by 534, becoming the law of the Roman Empire. This is known as the Justinian Code, upon which most of the legal systems of most European nations are based to this day. The principal source of American law is the common law, which had its roots about the same time as Justinian among Angles, Britons, and later sections in Britain. William the Conqueror arrived in 1066 and combined the best of this Anglo-Saxon law with Norman law, which resulted in the English common law, much of which was by custom and precedent rather than by written code. The American colonists followed the English common law with minor variation, and the 4-volume commentaries on the laws on England by Sir William Blackstone, completed in 1769, was the legal Bible, the legal Bible for American frontier lawyers, and influenced the development of state codes of law. To a great extent, common law has been replaced by written statutes, and a gigantic body of such statutes have been enacted by federal and state legislatures, supposedly in response to the greater complexity of modern life. Statute, ordinance, or regulation enacted by the legislative branch of a government and signed into law, or in some nation created by decree without any democratic process. This is distinguished from natural law, which is not based on statute but on elegant common understanding of what is right and proper, often based on moral and religious precepts, as well as common understanding of fairness and justice. And then the last generic term for any body of regulation for conduct, including specialist rules, military law, moral conduct under various religions, and for organization, usually called by laws. Uh, Laws inform everyday life and society in a wide variety ways, reflected by numerous branches of law. Contract law regulates agreements to exchange goods, services, or anything else of value. So it includes everything from buying a ticket, trading, swaption on a derivatives market. Property law defines people's rights and duties towards tangible property, including real estate, real property, land or building, and their other possession, personal property, clothes, books, vehicles, and so forth. And intangible property such as bank accounts and share of stocks. Tort law provides for compensation when someone or their property is harmed, whether in an automobile accident or by defamation of character. Those are fields of civil law which deals with a dispute between individuals, offenses against a federal, state, or local community itself are the subject of criminal law, which provides for the government to punish the offender. Society itself is built upon law. In the United States, constitutional law governs the federal government and its citizens, providing a framework for making new laws, protecting people's civil rights, and electing political representatives, while administrative law governs the way government agencies function. State, counties, municipalities, school boards, water district, and other local government entities are governed by separate system of law that define which a system are subordinate to which, so that conflicts between their provision can be resolved. International law regulates the affair between sovereign nation states in everything from trade to the environment to military action. Legal system around the world elaborate legal rights and responsibilities in different ways. Basic distinction is made between civil law jurisdiction and a system using common law, because it's a system derives from the common law system of England. The United States is a common law jurisdiction, as are its constituent states. Also, physics our civil law system survive in states such as Louisiana and California, with strong roots in France or a Spanish legal system. A few countries still base their law on religious scripts. Scholars investigated the nature of law through many perspectives, including legal history or philosophy and social science, such as criminology, economic, and sociology. The study of law raises important questions about equality, fairness, and justice. This is not always simple in its majestic equality, said the author Anatole France in 1894. The law forbids rich and poor alike to sleep under bridges, big on the streets, and steal loaves of bread. But as the ancient Greek philosopher Aristotle wrote in 350 before Christ, the rule of law is better than the rule of any individual. The most important institutions for law are judiciary, the legislature, executive government, its bureaucracy, the military and police, the legal profession, and civil society. How about legal subject? Different countries often categorize and name legal subject in different ways. Sometimes people distinguish public law subject which relate closely to the state, including constitutional, administrative, and criminal law, from private law subject including contract, tort, property. In civil law, system, contract, and tort fall under a general law of obligation, and trust law is treated with under statutory regimes or international convention. All legal systems deal with the same issues because the same questions are raised in every society. To practice law, students usually learn certain core subjects, which, for example, in England are European Community Law, Constitutional and Administrative Law, Criminal Law, Contract, Tort, Property Law, and Trust. However, there are many further disciplines which may be of even greater practical importance than the traditional core subjects and outside the AU. Students may focus on different agreements under international law such as NAFTA, SAFTA, CSN, ASEAN, or the African Union. The best way to grasp the importance of the subjects is carefully individually study. In a global economy, law is globally ceasing too. International law can refer to three things: public international law, private international law, or a conflict of laws, and the law of supranational organization. Public international law concerns the relationship between sovereign nations. Public international law has a special status because it has no police force, and its courts lack the capacity to punish disobedience. The sources of its development are custom, practice, and treaties between sovereign nations. The United Nations, founded under the UN Charter and the Universal Declaration of Human Rights, is the most important international organization established after the failure of the Versailles Treaty and World War II. Other international agreements like the Geneva Convention on the Conduct of War and international bodies such as the International Labour Organization, the World Trade Organization, or the International Monetary Fund also form a growing part of public international law. And then conflict laws or private international laws in civil laws countries concerned with jurisdiction. A legal dispute between private parties should be heard in and which jurisdictions law should be applied. Truly, businesses are increasingly capable of shifting capital and labor supply chains across borders, as well as trading with overseas businesses. This increases the number of disputes outside an unified legal framework and the enforceability of standard practices. Increasing numbers of businesses opt for commercial arbitration under the New York Convention 1958. European Union law or EU law is the first and only example of a supranational legal framework. However, given increasing global economic integration, many regional agreements, especially the Union of South American Nations, abbreviate in its spoken language as follows: in that Uni funds with American natives, UZAN, in Portuguese, União de Nações Sul-Americanas, or UNASUL, UNASUL. In Spanish, Unión de Naciones Suramericanas, or UNASUL, UNASUL. And Association of Southeast Asian Nations, abbreviated ASEAN, or are on track to follow the same model. In the EU, sovereign nations have pulled their authority through a system of courts and political institutions. They have the ability to enforce legal norms against for member states in citizens in a way that public international law doesn't. Therefore, European Union law constitutes a new legal order of international law for the mutual system and economic benefit of the member states. And then the next about constitutional and administrative law. Constitutional and administrative law govern the affairs of the state. Constitutional law concerns both the relationship between the executive, legislature, and judiciary, and the human rights or civil liberties of individuals against the state. Most jurisdictions, like the United States and France, have a single codified constitution with the Bill of Rights. A view like the United Kingdom have no such document. In those jurisdictions, the constitution is composed of a statute, case law, and convention. A case named Antic vs. Carrington illustrated a constitutional principle deriving from the common law. Mr. Antic's house was searched and ransacked by Sheriff Carrington. When Mr. Antic complained in court, Sheriff Carrington argued that were from a government minister, the Earl of Halifax, with valid authority. However, there was no written statutory provision or court authority. The leading judge, Lord Camden, stated that the great end for which men entered into society was to secure their property. That the right is preserved, sacred, and incommunicable in all instances where it hasn't been taken away or abridged by some public law for the good of the world. If the accused can be bound or produced, the silence of the books is an authority against the defendant, and the plaintiff must have a judgment. The fundamental constitutional principle inspired by John Locke is that the individual can do anything but that which is forbidden law, while the state may do nothing but that which is authorized by law. Administrative law is the chief method for people to hold state bodies to account. People can apply for judicial review of action or decision by local councils, public services, or government ministers to ensure that they comply with the law. The first specialist administrative court was the Conseil d'État, set up in 1799 as Napoleon assumed power in France. So the next about criminal law. Criminal law is the body of law that defines criminal offense and the penalties for convicted offenders, apprehending, charging, and trying suspected offenders is regulated by the law of criminal procedures. In every jurisdiction, a serious crime is committed where two elements are fulfilled. First, the defendant must have the requisite guilty mind to do a criminal act or mens rea or evil mind. In modern criminal law, it's recommended by the American Law Institute Model Penal Code and enacted in many states. Mens rea, also known as mental culpability, has four main forms: purposely or intentionally, as in intentional murder, knowing as in knowingly possessing narcotics, reckless as in reckless manslaughter, and criminally negligent as in criminally negligent manslaughter. The second, the defendant must commit the voluntary criminal acts or actus reus or guilty act. Examples of different kinds of crime include murder, assault, fraud, or theft. If relevant are illegit and proved, exculpatory defenses exist to crimes such as killing in self-defense or pleading insanity. A famous case in 19th century England, R.V. Chudley and Stephens, involved the defense of necessity. The Meek Note sailing from Southampton to Sydney, strength, 3 crew numbers and a cabin boy were stranded on a raft. They were starving. The cabin boy close to death, so the crew killed and ate the cabin boy. The crew survived and were rescued, but put on trial for murder. They argue it was necessary to kill the cabin boy to preserve their own lives. Lord Coleridge, expressing immense disapproval, rule to preserve one's life is generally speaking a duty, but it may be the plainest and the highest duty to sacrifice it. They were sentenced to hang. Yet public opinion, especially among seafarers, was outraged and overwhelmingly supportive. In the end, the crown commuted their sentence to 6 months. The offense that involve criminal law are those construed as being against the state. In common law countries, the government takes the lead in prosecution, and cases are such as the people fee or RV. Also, in many countries, lay juries determine the quell of defendants on points of fact. Although they may not change legal rules themselves, some developed countries still have capital punishment for criminal activity, but the normal punishment for a crime will be imprisonment, fines, or community service. Modern criminal law has been affected considerably by the social science, especially with respect to sentencing, legal research, legislation, and rehabilitation. The idea of a crime that puts one beyond the law of nation began with the doctrine of justice humanist journalists originally focused on piracy. The idea of a generic crime against humanity was brought out in the International Military Tribunal or Nuremberg. Such crimes were assumed to include genocide, although that isn't rigorously defined. On the international field, 104 countries have signed up to Rome Treaty, creating the International Criminal Court, which was set up to try people for crimes against humanity. Not all countries, especially major powers, have agreed to participate in this court, in part with concern about sovereignty and in part with concern that international humanitarian law can be used as a means of political lawfare. Note that the International Criminal Court is distinct from the International Court of Justice. The latter is intended to try states, not individuals, just where theory bears on national action. There has been somewhat more consensus on specific criminal courts, such as the International Criminal Court for the former Yugoslavia or the International Criminal Court for Rwanda. And then the next, I will talk about the contract. Contract is based on the Latin phrase "pacta sunt servanda." Promises must be kept. Contracts can be simple for the buying and selling or complex multi-party agreements. They can meet orally, example buying a newspaper, or in writing, example signing a contract of employment. Sometimes formalities such as writing the contract down or having it witnesses are required for the contract to take effect. For example, when buying a house. In common law jurisdiction, there are three key elements to the creation of a contract. These are offer and acceptance, consideration, and an intention to create legal relations. For example, in Cardinal versus Carbolic Smoke Bell Company, a medical firm advertised that it's a new wonder drug, the smoke board, would cure purple flu, and if it didn't work, fearing bankruptcy, Carbolic argued the advert wasn't to be taken as a serious legally binding offer. It was merely an invitation to trade or mere pub, a gimmick. But the Court of Appeal held that to a reasonable man, Carbolic had made a serious offer. People had given good consideration for it by going to the distinct inconvenience of using a faulty product. Read the advertisement how you will and twist it about as you will, said Lord Justice Linley. Here is a distinct promise expressed in language which is perfectly unmistakable. Consideration means all parties to a contract must exchange something of value to be able to enforce it. Some common law systems, like Australia, are moving away from consideration as a requirement for a contract. The concept of estoppel or culpa in contrahendo can be used to create obligations during pre-contractual negotiation. In civil jurisdiction, consideration is not a requirement for a contract at all. In France, in ordinary contract is said to bond simple on the basis of a meeting of the minds or a concordance of wills. Germany has a special approach to contracts, which ties into property law. Their abstraction principle, in the German language, abstractionist principle means that the personal obligations of a contract from separately from the title of a property being conferred. When contracts are invalidated for some reason, for example, a car buyer is so drunk that he lacks legal capacity to contract, the contractual obligation to pay can be invalidated separately from the proprietary title of the car. Unjust enrichment law, rather than contract law, is then used to restore title to the rightful owner. And then the next about tort. Tort, sometimes called delicts, are civil wrongs. To have acted tortuously, one must have breached a duty to another person or infringed some pre-existing legal right. A simple example might be accidentally hitting someone with a cricket ball. Under negligence law, the most common form of tort, the injured party can make a claim against the party responsible for the injury. The principles of negligence are illustrated by Donegal versus Stevenson. Mrs. Donegal ordered an opaque bottle of ginger beer in a cafe in Paisley. Having consumed half of it, she poured the remainder into a tumbler. The decomposed remains of a dead snail floated out. She fell and sued the manufacturer for carelessly allowing the drink to be contaminated. The host of Lord decided that the manufacturer was liable for Mrs. Donegal's illness. Lord Atkin took a distinctly more approach and said, the liability for negligence is not doubt based upon a general public sentiment of moral wrongdoing, for which the offender must pay. The rule that you are to love your neighbor becomes in law. You must not injure your neighbor. And the lawyer's questions, who is my neighbor? Receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. This becomes the basis for the four principles of negligence. Mr. Stevenson on Miss Donegal's duty of care to provide safe drinks. He breaches his duty of care. The harm would not have occurred, but for his brains and his egg was the proximate cause or not too remote consequence of her harm. Another example of tort might be a neighbor making excessively loud noises with machinery on his property, and a nuisance claim to noise could be stopped. Torts can also involve intentional acts such as assault, battery, or trespass. A better known tort is defamation, which occurs, for example, when a newspaper makes unsupportable allegations that damage a politician's reputation. For FMUs are economic torts, which form the basis of labor law in some countries by making trade unions liable for strikes when statute doesn't provide immunity. Okay, the next about property. Property law governs everything that people call theirs. Real property, sometimes called real estate or right in rem, refers to ownership of the land and things attached to it. Personal property or a right in personam refers to everything else, movable objects such as a computer or sandwich or intangible rights like stocks and shares or the copyright on a song. The classic civil law approach the property proponent by Friedrich Karl von Schwittke is that it is a right code against the world. This context to an obligation like a contract or tort, which is a right code between individuals. Preferred in common law jurisdiction is an idea closer to an obligation that the person who can show the best claim to a piece of property against any contesting party is the owner. The idea of property raises important philosophical and political issues. John Locke famously argued that our lives, liberties, and estates are our property because we own our bodies and mix our labor with our surroundings. The idea of property is still contentious. French philosopher Pierre Proudhon most famously proclaimed property is theft. Land law forms the basis for most kinds of property law and is the most complex. It concerns mortgages, rental agreements, licenses, covenants, easements, and the statutory system for registration of land, regulation on the use of personal property fall under intellectual property, company law, trust, and commercial law. And then about trust and equity. Equity is a body of rules from England that used to be a spirit for the common law. This law was administered by judges. The Lord Chancellor was the king's giver of conscience, had authority to overrule the judge's law if they were too strict. Equity operates by principles rather than rigid rules. Various civil law systems and the common law don't allow two people to split ownership of one piece of property. Equity allows this through the trust instrument. Trust is control property, whereas the beneficial or equitable ownership of trust property is held by people known as beneficiaries. Trusted or that is to the beneficiaries to take good care of the trust. For example, in the early case of Kids versus Sanford, a child inherited the lease on a market in Romford, London. Mr. Sanford was entrusted to look after this property for the benefit of the child until he was an adult. But the lease on the market was about to expire, and the landlord had apparently told Mr. Sanford that he would renew it for the child. But the landlord was happy. He instead to give the opportunity to Mr. Sanford. Later on, the grown-up child, Mr. Case, sued his old trustee for the profit, for the profit that he had made by getting the market lease because it represented a conflict of interest. The Lord Chancellor, Lord King, agreed and ordered Mr. Sanford should discharge his profit. He wrote, "I very well see if a trustee on the refusal to renew might have a lease to himself few trust estates would be renewed." This may seem very hard, that the trustee is the only person of all mankind who might not have the lease. but it is very probable that the rule should be strictly pursued and not all relaxed. Of course, Lord King LC was worried the trusted might exploit money they were meant to look after for their own benefit instead of doing their job. Just recently, there had been a stock market crash involving abuse of trust. Strict judges alike this made their way into company law and were applied to directors and chief executive officers. Another example of a judge might be for the trustee to invest the property wisely or sell it. This is especially the case for pension funds, the most widely used type of trust, where banks are trusted for people's savings until their retirement. But trust can also be set up for charitable purposes. Famous examples being the British Museum and the British Museum or Rockefeller Foundation. Okay, I think enough my explanation about law. Maybe the next part I'm going to talk about the history and legal system of law of Indonesia. Okay, thank you very much. Thank you for your attention. Thank you so much. Bye bye. Assalamualaikum warahmatullahi wabarakatuh.